a friend, a neighbor. If you have a question, give us a call, 850-392-1544. Before we get started with the show, we always take an email question, and let's go ahead and put that up. Okay, email question says, my in-laws own a rental house and they hired me to fix some loose gutters. Long story short, I fell and tore 2 tendons in my right shoulder. Their insurance has been nice so far. They only mentioned paying for medical bills during the first interview, and I want to know if I can ask for wages or something else to help with the expenses. I'm self-employed with no additional insurance. The doctor told me don't use my arm for at least 8 weeks. I have a wife and 2 kids who depend on my income, and that comes from Dave. First off, Dave, very sorry to hear about the injury that occurred. Sounds like you were trying to help your friends out, and unfortunately there was an accident that occurred.
He's helping his in-laws out.
Oh, it was his in-laws, that's right.
Oh, he was charging them.
Oh my gosh, probably double, right? That's right. Ted Howell, everybody.
How you doing?
So Ted, you know, Dave's kind of in an interesting predicament there because they didn't say anything about liability first off.
Correct. I mean, he asked if he can ask. You can ask for anything, Dave. The bigger question is, can you legally, are you entitled to it? And as you said, with the information we have in the email here, it's difficult to ascertain what, if any, liability your in-laws have for the injury that you suffered, because as we've talked about many times on this show, just because you've had an injury on someone's property does not mean that that property owner is liable for that accident. There has to be negligence, the failure to use reasonable care under the circumstances. And so if, for example, in the gutters you were dealing with, there was some sort of dangerous condition that they knew about and didn't warn you about or failed to somehow remedy before you got there, there's the potential that they could have liability. And if they do have liability, then you would be entitled to recover not only your medical expenses, but also any lost wages, pain and suffering, things of that nature. But the biggest issue we have to ascertain in order to understand if you really are entitled to that is whether or not there's legal liability on the part of that homeowner.
Right, and an example of that would be, let's say you're going over and you're using some of their equipment. They let you borrow their ladder, and your in-laws know that this is an old ladder. They know it's defective. They know the third rung has a tendency to give out, and they've got it held together by a zip tie. You know, but they say, hey, go ahead and use this ladder, and you go up and you do it, and in the process you fall and you hurt yourself. Well, then that might quite possibly put liability on their part, in which case you would have, most likely their homeowner's policy would have a liability coverage provision in it, and you could seek the damages that Ted just talked about if you can establish the liability. Now, beyond that, some homeowners' policies have a type of coverage called MedPay. And what MedPay is it's a medical payment insurance, MedPay, medical payment. If you're injured on the property, regardless of fault, that MedPay coverage will provide coverage for medical expenses only. Now, normally the MedPay limit is relatively small compared to what we see in terms of medical charges these days. Anywhere from $1,000, sometimes I've seen it as high as $5,000, even $10,000. But it's kind of a no-fault insurance. If you get hurt on the property, then you're entitled to get that MedPay coverage if they have it on the policy. It's not a requirement to be on a homeowner's policy, but a lot of homeowners policies do offer that type of coverage. But you know, Dave, I hope things work out. I hope it doesn't take as long for you to heal. 8 weeks is a pretty long time, especially when you're having to take care of a family.
Right. And good luck with your wife if you have to pursue that.
Oh yeah, no kidding. Yeah, good luck with the in-laws. We actually have a call tonight. Richard, go ahead with your call.
Hello.
Hey Richard, go ahead.
Yes, I was walking into a business and they have a handicap cut out on the sidewalk for wheelchairs.
Mm-hmm.
And I tripped over the edge of the concrete because there was no markings or painted stripes or anything like that. And I tore my right knee up. I'm going to have surgery on my right knee, and fractured my left hand, and I have to have surgery on my left hand. And I notified the people, and they were just like, well, we can't do anything about it.
Okay, and you said this was a business?
Yes.
Okay. Richard, can you give me a little bit more information? You mentioned that it was the handicap ramp, which I'd normally associate that with being close to a handicap parking space, but I'm guessing it's just a ramp, a simple ramp that that led up from the parking lot up to a sidewalk that would go around the business. What part did you trip over?
Where they got the sidewalk cut out for a wheelchair to go up, I tripped over the front corner of the sidewalk because I couldn't see it.
Okay. Is there a reason you couldn't see it? Was it painted the same color? Did it kind of blend in with everything around it? Or tell me a little bit more about that.
It blended in with the parking lot because there's no markings, no painted lines or anything.
Okay. Okay. You know, Richard, like the email question we just had, the reason I was asking you those questions is because anytime you're talking about a premise case, and we talk about premises liability, injuries that occur on somebody's property, facts are very important. You mentioned that you tripped over this cutout. You mentioned how it blended in with the color of the parking lot. You know, normally if you're in other businesses, and you know, just think about where you would normally go during the normal course of your day. You go to the grocery store, you know, you see there's lines, there's yellow markings, there's stripes, there's all sorts of things, and those are designed to draw people's attention to those changes in elevation. Now, the courts in Florida have said that a simple change in elevation in and of itself is not a dangerous condition. However, in your situation, there may very well be liability. And
right.
Ted,
and there's a lot of difference in the change in elevation in a private residence versus a public business where you have, and you know, we've had cases before where the situation is maybe not dangerous in and of itself, but the way it is visually depicted so that you can't see it. The change in elevation is obscured by the way it blends together. I know we see that a lot of times in steps and how that works when they paint them all the same color. So there is a situation there that we potentially would have to look into, but a lot of it would come down into how big is the height differential, how much does it blend together, and that would all need to be looked at and ascertained, and we'd want to make sure as well, Richard, if there was any video footage of this, if it happened in front of a business, there's a good likelihood that they have surveillance footage of it, so we'd want to capture that so we make sure and have a clear and accurate depiction of what actually happened. But it's definitely something worth pursuing and worth looking into, so definitely give us a call and when we can reach out to you tomorrow to make sure we get all the details we need so that we can make sure that it's looked into properly. Yeah,
you know, Ted, another thing he mentioned in there about how it blended in, you know, we normally think about these areas being properly marked, and that's for a reason.
Big yellow paint.
That's for a reason. It's to provide that visual cue that, hey, there's something going on here. You know, one thing that we'll probably also be looking at is whether or not, if this was just a basic cutout, you know, was it ADA compliant?
Right.
Did it comply with local and state building codes to have it done the way it was done? I mean, you know, usually when I see these types of ramps, I mean, they are. Because most contractors and builders that build these types of areas know what the codes are. But if this was like a makeshift type of a ramp,
right,
you could very well be dealing with a code violation, which actually in Florida can make a pretty big difference, because if you have a violation of any applicable code, that is considered prima facie evidence of negligence in and of itself. Now, it's a rebuttable presumption, but it's something that you can point out to the court and say, look, I tripped over this and there's a code violation, versus I tripped over this and I just didn't see it. Factually, you know, you still tripped, you still fell, you still hurt yourself, but just those little bitty nuances there could make a big difference. You know, especially these days, Ted.
I was going to say, and in the world of a trip and fall case in Florida, historically we have had what's called pure comparative fault, which means as long as the tortfeasor, i.e. the person that you are seeking to collect against, has some sort of culpability in the accident, even if you bore a large percentage of responsibility, even up to 99%, if they were only 1% at fault, you could still recover for that 1%. Unfortunately, our legislature has decided to change the course after all these years, and now if you are 50% or more, just over 50% responsible for the accident, and you bear that much responsibility, you're going to be completely precluded from recovering anything. So that is a large change in Florida law that will go on the books here effective now. And so it's going to really change the way Florida citizens are allowed to recover for various types of injuries in the negligence realm.
Yeah. So Richard, again, we'll reach out, let us know if we can do anything to help you out. That's exactly the type of claims that we handle. You know, it's very unfortunate that this happened to you, but if there's anything we can do to help you out, we'll certainly do that. You know, Ted, talking about the changes in the law that we've just had, the governor just signed this omnibus tort legislation bill, which really changes a lot of the way we're going to be evaluating cases.
Right.
But another thing it does, and this is something that anybody that has a claim or has, is thinking about bringing a claim, something happened to them. It used to be that in Florida, if you were involved in a car wreck, for example, you had 4 years from the date that wreck happened to bring a lawsuit. Now, 4 years seems like a very long time, and it is, but sometimes there's complications, sometimes there's extensive medical treatment, sometimes the care and therapy requires extended treatment. Sometimes you have problems finding witnesses. Sometimes it just takes a while to build the case. Now, going forward, you no longer have 4 years to bring a lawsuit. You now have 2 years to bring a lawsuit. So they've cut the statute of limitations down from 4 to 2. They cut it in half, right, which really just means this. If you are involved in a wreck, if you have a trip and fall, slip and fall, any type of an injury claim, it is more important than ever that you reach out to an attorney to make sure that your rights are protected. The amount of time has decreased, has been cut in half. The comparative fault law has changed. There's also been some changes to how we deal with insurance companies. Back in I say the good old days, starting a week ago, and going backwards, there were certain tools we had in our toolbox to hold insurance companies accountable for delaying a claim or denying a claim wrongfully. And now a lot of those tools have been removed from that toolbox. So it's some pretty drastic changes in the law. We're still going to fight for people's rights to make sure that they get justice if they've been wrongfully injured. There's just going to be a different fight to wage these days with the change in the law.
Right. It's more important than ever, as you said, to make sure and prosecute and pursue those claims timely and make sure that you have someone helping you through that process, because it just got a lot harder for everyday Floridians, and unfortunately, insurance companies and big business have a lot to be happy with right now.
Yes, they do. Yes, they do. We're going to take our first break of the night. We'll be back right after this. Welcome back to Law Call, where we're taking your questions live and also your emails. If you want to send us an email about an injury question, feel free to do so. The email address is lawcall@mypanhandle.com, I believe, or is it WMBB.com?
WMBB.com.
So there it is, lawcall@WMBB.com. You know, Ted, before we went to break, you know, we were talking about the types of auto wrecks and things like that, but there's also other types of claims that can be made from a civil standpoint that people may not necessarily think there's a civil cause of action behind.
Absolutely, and you know, both of us have had several cases where the actual underlying case is a criminal case. I mean, obviously in our auto accidents that are DUI cases, those are criminal, but there's also, you know, we've had several cases where the person has been either a victim of battery or sexual assault or other criminal charges, even murder. And you know, the issue is a lot of people think it's criminal, it's just criminal, but essentially almost anything that is criminal would also have an underlying tort cause of action that you can pursue. In all honesty, usually the big impediment is that there's not going to be insurance coverage for intentional acts, but there is potential to navigate that and potentially procure coverage. Or otherwise, just because you don't have coverage doesn't mean that you can't collect from the actual tortfeasor. That just becomes an analysis of whether or not they actually have assets under Florida law that would be subject to judgment and execution. So that becomes a whole different analysis. But it's something that should absolutely be explored and properly looked at anytime you've been a victim of a crime.
Right, and you know, a lot of times I've been asked by my clients, especially, you mentioned the DUI case. You know, unfortunately, we help people all the time that have been involved in car wrecks, and sometimes it's because there was a drunk driver on the other end. Tess Rowland, you know, was you know, the victim of a drunk driver. So I mean, people we know, our friends, our neighbors, and there's a criminal process that goes with that. And as a part of that process, they talk about restitution.
Correct.
And restitution is a criminal part of the criminal case where they will, you know, they'll carve out money, or they'll require the criminal defendant to pay money to go towards certain expenses. That is different than what Ted's talking about. We would actually go forward and file a civil lawsuit against that individual, whereas restitution might be limited because oftentimes there's an inability to pay a lot of money. We still may have those limitations, but we can go after a lot of things that the criminal courts and the criminal prosecutors may not necessarily go after. But it's like just like filing a lawsuit. So if you know, you're out one day and somebody sucker punches you in the back of the head and you go down and you're injured and they're charged with a crime, well, guess what? That's the tort of battery. Right. We can file a civil lawsuit against that individual for committing battery against you. We've had people that have been victims of shootings. We've had people that have been victims of sexual assault. You know, sometimes there is a third party. You may have the criminal case. You know, you talk about the sexual assault case. You may have a criminal case, but what if it occurred in the confines of like an educational setting, right, or a church setting? You know, those things happen. There could actually be third party liability that goes along with that as well. So again, it's very fact specific. So I guess the takeaway is this: if you've been wronged, if you've been injured, if you've been hurt, whether it be by accident or intentionally because, you know, through a crime, absolutely give a lawyer a call and see what they can do to help you out.
Right, and it's always nice because when, you know, when the state pursues it, that the state is doing that and they control that claim. When you've been a victim and you hire us, we're representing you directly, and you have a lot. It oftentimes empowers the person because they then have a lot more of a. We represent them, they get to talk to us, and we dictate how they get to pursue that. So I think we got a call now from John. Yeah, we
did. John from Houston County, across the state line. What's going on, John?
I got hurt at work, and I went to the hospital. I hurt my back, and I wonder if I ever came.
Hurt on the job.
Well, yeah, John, if you're hurt on the job, then that is going to clearly implicate what's called workers' compensation. And so one of the quid pro quos of the workers' compensation system is that if you're hurt on the job, then you're entitled to be compensated under that system. Now, it is more limited than what you can recover under a normal tort or negligence theory, but it will pay and compensate you for your medical expenses, and depending on if you have to miss work, they have what's called an aspect that's called indemnity or payment for your lost wages, and there's scales that and systems that determine how much you get depending on how long you have to be out, what the nature and magnitude of your injuries are, but you most certainly have a claim under that system. Now, without any more details and knowing about exactly how you hurt your back, for example, if you had been in a car accident while on the job and someone hit you and they had caused the accident, you would have not only a workers' comp claim, but also a motor vehicle negligence claim against the person that hurt you. If you slipped and fell on a premises other than your employer's premises and there was some sort of defect on that property that caused the accident, you would have a premises liability case in addition to the workers' comp accident. So, you know, Les, we frequently have
because there's a lot of different factors that go into it. It's called the Manfredo formula. I don't want to get too deep in the weeds with it, but there is obviously that third-party aspect that your insurance company on the workers' comp side has to help you with. So I think we have one more call, but we're going to take a break real quick, and we'll get a call from Sean when we get back.
All right, Sean, if you're still on the line, if you could ask your question, please.
Okay, yes, sir. I have a active situation where my check is being garnished from an injury that occurred when I was a minor in high school. I had knee surgery in '99, and I want to say that I'm not responsible for fronting that bill. It should be like on the school part or my parents. I don't know the law like that, but I just had a question wondering why my check is being garnished like 20 years later.
Sean, was that surgery back in 1999?
Yes, sir.
Okay, yeah, it sounds like there's some more details maybe we would need, Sean, but I mean, typically a debt would not exist that long. We'd be well past the statute of limitations unless it went to judgment a long time ago.
Right. One of the questions I had, Sean, do you know who originally paid for the knee surgery and who it is that's garnishing your wages to get money back?
I'm paying Lewis and Brack.
That's
like a collection. That's a collections
that's a law
outfit.
firm. So
You know, Sean, so what you probably need to do is you need to talk with an attorney that does a lot of collections work and the defense of collections and creditor claims. There's federal and state laws that deal with the collections of debt. There are rules that they have to follow, and if they are attempting to collect a debt that is invalid or that is an illegal collection attempt, they can be subjected to some pretty hefty penalties.
Absolutely.
And you know, the number one thing that I heard, you know, was 1999. You're talking 24 years ago. I mean, I don't know of any claim that can survive that long unless they had a judgment and unless they continually renewed that judgment. But that seems very
add
unlikely.
the minor aspect to it. There's a lot there, and a lot of times you look at attorneys in the bankruptcy arena that also do debtor protection and Fair Debt Collection Act practice type work, but there's definitely something that needs to be looked there, Sean. And if you'll give us our office a call, we don't mind pointing you in the right direction so that you can make sure and get help, because that's definitely a situation that needs to be addressed very quickly.
Yeah, I would. The first thing I'd be looking at would be the Fair Debt Collection Act. It's a federal statute. There's that just seems off. That's the first. That's the first one. That's a new one, Sean. Congratulations, you gave us a new question.
Sorry
we
you're
hadn't
dealing
heard.
with it though,
But,
especially this long afterwards.
Yeah, absolutely. Well, I think we're getting down to the wire here. Got a couple minutes left, maybe a little bit less. Minute and a half.
Okay.
You got any shout outs?
Let's see. I need to give a shout out to Trina Birch and Chris Harp, and let's see, my wife Heather, and I don't think I have any else.
I can't believe you left off G Money.
Oh, Gary Starr, yeah, Gary's watching us. Yeah, he's watching us. And also, if you know, you can now watch us on YouTube and Facebook Live. I learned,
I know.
and they're watching there.
I know. So. It's an opportunity for our friends that don't live in town to comment live.
Exactly.
I want to give a few shout outs. Miss Pam, of course, she's watching us. Nick and Lauren, Jamie and Ed, thank you for staying up. My buddy Arthur is tuning in. I know he's watching because he's been texting us.
Yeah.
I want to give a big shout out to Rick and the Marlin Man. Good to see you always. And Perry and Young staff, as always.
All of them.
They do wonderful work. Nicole and the Buck.
Yeah.
Got to say hi to the Buck.
Make sure and get out there on Facebook and Google and leave us a review if you like our work, please.
And I better give a shout out to my beautiful wife and my kids who are staying up watching. If I don't do that, I'm in trouble.
Ooh.
So, thanks for tuning in. We'll be back next week, same bat time, same bat channel. Give us a call next week if you have any questions. Otherwise, we'll see you then.
All right.